Ma'am, আমি MSc appeal Milan, 2022. Maybe listed Milan 11.
When?
11.
11th.
11.
Under which column?
It will be motion. Sorry,
Motion.
admission.
Admission. Okay.
May I please, Your Lordship?
Yes.
So with concern of the other side, I would like to make item number 11, Lordship. I am for the respondent. Appearing on behalf of Mr. G.P. Gomez, one senior counsel. Madam, we fix after 1 week, Lordship. Next Tuesday,
You're for respondent.
respondent. Appearing on behalf of Mr. G.P. Gomez, one senior counsel.
GP?
G.P. Gomez, Lordship.
Acha. Your good name?
D. Kolita.
Mr. D. Colita, learned counsel appearing on behalf of Mr. G.P. Bhaumik, learned counsel for the respondent. With consent from the other side, press for listening the matter. When?
Next Tuesday, Lordship.
In the month of December. Hearing matter. On 10th December.
Oblige.
May I please, Lordship? I would like to mention one MSc appeal of 2020, Lordship. It's a death case. It was listed lastly on 27 March. Lordship.
Oh, hearing.
Under order column. Lordship. Next Monday, Lordship.
Not Monday, on 13th.
13.
13th.
May I please, Your Lordship?
Lordship, I beg to mention for the listing a matrimonial appeal, Lordship, next week, Lordship, on 15, Lordship.
15 holiday.
Admission,
15th is holiday.
next,
Then on 18th.
yes.
It please, Mr. Lordship, my lord. My lord, RSA, my lord, 2014 matter, my lord. This matter is ready for hearing, my lord. I am praying for listing on my lord 12/11, my lord.
Not in the month of November, in the month of December.
My lord.
December. On 10th. 10th December.
Right.
May I please, Your Lordship? I beg to mention item number 18, Lordship. May I pray for fix the matter on 13, Lordship? My learned friend has consent, Lordship.
On 15,
13, 1-3.
13.
Okay.
Your good name?
S.H. Raman.
Mr. S.H. Raman, learned counsel with counsel for the appellant with consent from the other side. Press for listening the matter on
On 13th.
November.
November.
Okay.
Oblige, Lordship.
May I please, Your Lordship? Lordship, I beg to mention a new arbitration appeal, Your Lordship, on Friday, Your Lordship.
Friday. On 7th. On 8th.
Deeply.
May I please, Your Lordship? To beg to mention for listening for pending civil revision petition, Lordship. The
When?
last date, Lordship, we have filed an IA for condemnation of delay. Notice was issued in the matter. We've taken steps, Lordship.
On
Lordship, last week we have taken steps. Lordship.
on who is that?
Lordship, any date will be.
On 22nd November.
May I please, the Lordship? Lordship, I beg to mention for listing of a regular second appeal for substitution of the respondents.
When?
Any date, Lordship.
On 25th November.
So obliged, Lordship.
But in a short, my lord, I am the plaintiff. When a plaintiff witness is closed, my lord, I have filed an application for adjournment, but that was not allowed. Only problem is this, my lord, case is fixed tomorrow. Case is fixed tomorrow for DW evidence. My lord, it is matter urgent, my lord, at 2, my lord.
No, not today.
My lord. Tomorrow then, my lord.
Tomorrow we can try.
Tomorrow. Hearing.
Tomorrow.
Tomorrow.
Lordship, may I please, Lordship, I beg to mention item number 5. Lordship, we are filing objection to this. So Lordship, this matter may be fixed on Friday.
My lord, in this case, they have taken time for about 4 days, Lordship, 4 days. So on Friday, then they are praying, Lordship, along with the objection, Lordship.
Okay. As agreed by learned advocates of both the parties, resist will list the matter on Friday.
Along with the objection, Lordship. They are going to file, not yet served a copy
We
to
are
us.
filing today, Lordship.
Okay.
That should be
Along with the objection petition.
filed by the opposite party. Oblige.
Another prayer, Lordship, I beg to mention item number 9, Lordship. Allow us 2 weeks time to reconstruct the file, Lordship.
You inform the other side?
Lordship, I am for the petitioner. I will inform them. Number is.
No, you first inform them.
Your lordship. Highly obliged.
Mm.
May it pleases your lordship, with the consent of the other side, I beg to mention item number 8 of today's list. Lordship, kindly adjourn the matter for the day and may be listed after a week, lordship.
I am for the appellant, my lord.
Okay, Miss, your good name?
B. Devi, lordship, for the
Miss
respondent.
B. Devi, learned counsel appearing on behalf of, counsel for the respondent. With consent from the other side, press for listing the matter on
3rd week of November, 4th week of November.
fourth week.
My lord, it is
Okay.
part heard, my lord, already.
It's a part of matter, Your Lordship. On 28 November.
28 November, my lord.
Okay.
Obliged.
Yeah, please, Your Lordship. I beg to mention for listing a matter for withdrawal, Lordship.
When?
Any day.
Tomorrow,
Obliged.
yeah, please, ma'am. Okay, for listing upon civil division petition for motion on Monday, ma'am.
Monday. Okay.
Obliged. May I please, Your Lordship? I beg to mention item number 12 or senior is out of his presented the matter.
Item number 12.
Oh.
12.
Yes, Lord.
You are for respondent,
Petitioner,
petitioner,
Taylor Mazumdar.
LR Mazumdar. You inform the other side.
No, no.
You first inform the other side, respondent side. Only thereafter we will consider your case.
May I please, Your Lordship? Paper listing of a MSc appeal for hearing, Lordship. So,
When?
last
December-
week of November.
December,
Last week.
December first week, on 5th December.
Okay.
For motion, item numbers 1, 2, and 3.
The order of the dictation is about partition the role transfer petition. What happened? Last Diwali again. Abhi tak continue karo matter.
The last occasion, if you lordship would recollect, madam, my learned senior friend had, because there were two CRP, CRP 1 and CRP 2. Now, by when administrative order, Honorable Chief Justice has transfer petition 1, criminal transfer petition 1, and CRP 2. So CRP 1 was left out. So last date, if your lordship goes through the order, madam, my learned senior wanted to clarify this matter. Whether CRP 1 has been transferred or not. Because from the order of the Honorable, administrative order of the Honorable Chief Justice, it transfers that CRP 1 was not transferred.
Question is different, man.
No, thereafter the registry has put up another note
When, my lord?
It has been.
before the Chief Justice, and now Chief Justice has transferred the other matter also.
With the lordship's indulgence, may I just go through that note? Perhaps
Yes, definitely you can go through it.
Just now it has been tagged with the record.
Yes, yes.
So let us, after some time, your lordship will take it.
Okay.
You can just see it from me. And just see it, we'll wait. Because that has been clarified. As soon as your lordship said that clarification is there,
Okay.
that has been affirmed by the honorable chair.
Let us go through.
They're just going. For admission, item number 4, part heard matter.
Asik. Huh? No, order to complaint নকৰিলো পিছত আকৌ বেলেগ এটা order হেৰি
Item 4.
Yes,
Hello,
yes,
this is here. To place my name. DLC, state level committee.
Hmm.
State level committee meeting. My lord, my name is considered in the DLC. Space 103. One 103
Hmm.
space. Therefore, the prior petition along with Honorable High Court order dated 27/10/2021 passed in WBC Nong 04/2020 is forwarded making necessary actions directed by the Honorable Court. My lord, and as such in page 104, there are
No,
there are
Mr.
one-
Das, on the other day, we have heard you.
Hmm.
Today, we have fixed the matter for production of the notification by Mr. Soikia.
My,
Mr. Soikia, that notification is available.
My-
with him.
serial number one, my lord, third paragraph from the bottom is the available.
Serial number?
Serial number one, in the
One.
first page.
But the present case relates to the year prior to coming into force of this notification.
My lord.
Hmm?
My lord, that time, my lord.
Can you take the plea that it is effective from the
It is just 2006.
Hmm?
2006.
So nothing has been mentioned in this memorandum that earlier notifications were cancelled,
No, my lord.
yeah, or superseded.
No, no. No.
Then
Initial, my lord, 1983 notification, this is enacted the policy of the compassionate appointment. That there is a no time bar in the original application.
so the petitioner will be governed by that notification.
Ex, my lord, there is a judgment come from this honorable court, my lord.
Hmm.
That Ashok Ranjan Das, my lord.
Hmm.
That judgment fixed for 1 year, it is 2004, my lord. That said that within 1 year, they have to file the.
1 year.
1 year, my lord.
Where is that
Subsequently-
judgment? Okay. কেটামান judgment দিছিলে না এইকেইটা কি হ'ল? এইকেইটা কি হ'ল? ওলাকে দিছিলে না? এখনো তো মনে থাকে আমি শেষে কিন্তু ফটো করে দিয়েছি। আচ্ছা। Okay, Mr. Sokia, you furnish it to the court.
My lord. Now, my lord, we are relaying that case, my lord, Debobroto Tiwari, my lord. So I have already placed before this honorable court that Debobroto Tiwari case, my lord.
That's clear.
Debobroto Tiwari.
Debobroto. There is a paragraph 7.5, my lord, that is a specific, my lord, saying that if any delay has been over.
Paragraph number?
7.5. Paragraph 7.5, my lord.
Okay.
This,
Any other point?
my lord, this is the latest judgment of the Supreme Court, my lord, where, my lord, other cases, NC Santos is relied by the petitioner, and other cases that have already decided. And subsequently, Supreme Court has given this mandate by saying that since it is a compassionate appointment, because that person who died within immediately assistance is required. Then it is even pending due to the fault of the government also, then it cannot be considered, my lord. This is the mandates of the Debobroto Tiwari. By virtue of the Debobroto Tiwari, my lord, state government has issued another notification in 2024 saying that there will be no further compassionate appointment since scheme has abolished in 2017. My lord. And here another question is
That
also there.
notification is available with you.
My lord, that has I have already submitted before this honorable court, my lord.
No, the notification you have submitted today
My lord,
is
today
dated
the
2nd March 2009.
notification. In earlier occasion, my lord, I submitted that notification.
You have a copy with you?
A copy of that will available in my office, my lord.
You can furnish later on also.
My lord, my lord,
You submit it to the court master.
my lord.
So any other point? No.
My lord, that's point, my lord, already clear. Like another problem is there, my lord, 2006 his father died, my lord. As per the mandates of this honorable court as well as the Supreme Court, within 2 years that have to be decided. Now, 2006 to 2008, 2 years has already left, my lord. Subsequently, 2010 judgment also said that other application receiver is pending that have to be decided by the government, my lord. In this concern, my lord, petitioner pursuit, my lord, that have to be decided by the government, my lord. And now question is that, my lord, if 2006 to 2008, now vacancy we cannot be accommodated, my lord. Because, my lord, that point of time, compassionate appointment made the year-wise vacancy, my lord. Then vacancy already filled up, my lord, under the scheme, my lord. And scheme finally abolished in 2017, my lord. Now we are in 2024, my lord. That considering that aspect, my lord, my prayer will be that, my lord, may decide the matter as per the Debobroto Tiwari, my lord, where Supreme Court has taken all view of the other judgment passed by this honorable court and the honorable Supreme Court also. In that view, my lord, may dismiss the writ petition. And if we are go to the 1983 notification, my lord, that has a specific, my lord, immediately financial assistance to the dependent of the deceased person. My lord. If he can survive more than, my lord, 20 years, my lord, definitely he have no right to claim under the compassionate appointment, my lord, because it is not a regular appointment, my lord.
Okay. For Mr. Edas, learned counsel for the petitioner, and Mr. P. Soikia, learned counsel for the respondent number
2 and 4, my lord.
2 and 4, and Mr. Soikia for respondent number.
Yes, for respondent 1, 3, and 5 also.
Argument concluded. Judgment reserved.
No, sir.
Item for hearing under order 41, rule to CPC. Item number 6.
My lord, in this appeal, it has been found that some defect has remained. While admitting this appeal, it was admitted without framing substantial questions of law, although I submitted this. So I require some time, my lord, to get it regularized. And also some person has expired, or if she is required to be substituted. So 3 weeks time may be granted.
3 weeks.
3 weeks.
Yes.
My lord, as per order dated 17/2/2020, lordship,
Hmm.
no substantial, though appeal was admitted, lordship,
Yes.
but no substantial question of law has been framed, lordship.
So this is regard to.
I learned senior has not also implemented the person who was a party before the learned court below. And she died, lordship, and her legal years is also not in the appeal, lordship.
Okay, let him
Lordship.
let him correct the matter. Heard Mr. N. H. Mazhar Bhuiya, learned counsel for the appellant, then Mr. Bhuiya, learned counsel for the respondent.
Majumdar, lordship.
Mozumdar, okay. Mozumdar, learned counsel for the respondent. Mr. Mazhar Bhuiya, learned counsel for the appellant, submits that he may be granted 3 weeks time to implement the legal heirs of some of the respondents.
Yes.
Some of the respondents.
Who is also not a respondent in the appeal also, but in the suit,
Some of the defendants or some of the parties.
Pair is accordingly allowed, recessal is the. It's
and regarding substantial question of law, lordship,
Next day.
next day, lordship, otherwise this appeal will remain, but no substantial question of law has yet been framed, lordship.
Next day time.
okay. First, I'll let him
Yes.
Lordship.
make necessary correction in the appeal. Thereafter, we'll consider that aspect because it may not be his fault also. He might have suggested the substantial.
Lordship,
question of
lordship,
law.
I will not propose that, lordship. It is up to the court, this court anytime can frame such a question.
Yes.
of law, lordship. My obligation.
Pending item 1, 2, and 3.
Well, I have gone through the note of the Honorable Chief Justice. As per your Lordship's direction, the first note whereby this administrative order was passed, as per your Lordship's direction, we has approached the registry. Now registry has not provided us with the copy. Our prayer has been rejected. The order dated, my lord, 31/3/10. Because the Lordship on last occasion will recollect, your Lordship has asked us to approach the registry. We have also applied for the certified copy. The registry has rejected, we are also not given the certified copy. So if your Lordship kindly pleases, Lordship may at least furnish us a copy of this and let us examine, let us take instruction.
My lord,
Whether, because, my lord, the issue involved is when a judicial proceeding is pending, whether by way of an administrative direction, a judicial proceedings can be nullified or not. So let us.
No,
take-
he want to withdraw it. He has the liberty to withdraw it.
Well, in that case, if transfer petition is withdrawn,
Hmm.
then CRP 1 and 2 will go back to the principal.
Why?
Already from here.
You do not know the power of the Chief
Then-
Justice.
Yes.
So the-
Well, it is-
If,
but-
if
no, no.
you want to question the power of the Chief Justice, you go to the Supreme Court.
No, that is why, then another aspect is there, my lord, the Lordship will kindly see, these matters were taken, if he, my learned senior wants to withdraw it, the matter was taken by the division bench, my lord, and the Lordship will kindly see. So whether a matter which was being presided over by division bench, whether a single bench can entertain an application or not, let it be placed
Which
before a
one?
division bench, my lord.
Which one?
This matter, my lord, Lordship will kindly see these first 2 orders, it was a division bench
I
matter,
have only one submission to make.
because this, when the
They had-
notice was issued, it
No,
was
no.
by division bench.
Now we are on the transfer petition
No,
number
that is why, my
92
lord,
of
this
24.
transfer, my humble submission is that, my lord, this transfer petition was taken by a division bench. Initially was moved by division, was taken up by, subsequently it was also taken up by division bench.
No,
if
today
you-
it is placed as per order of the Chief Justice.
No,
You
that
go
is-
wherever
no,
you
my
like.
lord, the
No,
Honorable,
sorry.
Honorable Chief
Sorry,
Justice,
sorry.
Honorable Chief Justice. has
Sorry,
never
Mr. Das.
stated- No, my lord, with all respect, my
You,
lord.
you are not allowed to submit on this point.
No, my lord, Honorable Chief Justice has never said that let it be laid before a single judge. That is only my respectful submission.
Cause list was prepared on whose order? You do not know the authority of Chief Justice.
No, no, my lord, I am fully aware of this, but
Then
my lord, in that case.
why you are
Why,
objecting?
why the, my lord, matter was taken upon by the division bench, my lord. If it had been a single bench matter.
You go and question before the Chief
my
Justice
lord,
then.
that is why my lord will at least furnish a call, direct, give a direction
Sorry.
for furnishing a copy.
Sorry.
Lord, the registry is saying that no, they will not give the paper. Now we have.
You avail the option available.
It will take 30 days, my lord. Availability, that's right, RTI.
Whatever option
Everything is
available, you
going
go
behind
there.
the back, my lord.
They have read
Very
the orders.
sorry state of affairs.
Just now they have read the orders. Even I'm yet to read it. And I'm told the order clearly
Okay, take down.
specifies.
Heard Mr. Balagopal, learned counsel for the petitioner. No, learned Advocate General Nagaland, assisted by Ms. So-and-so, learned additional senior government advocate for the petitioner. Mr. Balagopal, learned counsel for the petitioner, submits that
Advocate General.
he has the instruction to withdraw this petition.
In the
Yes.
light of the matter being transferred,
As
petition. being
by an
transferred.
administrative order dated 4/11/2024 and Three 10/2024 civil revision petition number 2 of 2024 and 1 of 2024 have already been transferred to this court. And as such, this petition become infectious. Having heard the submission of Mr. Balagopal, learned Advocate General, this court deem it proper to deem it this court inclined to permit him to withdraw this petition. Accordingly, this petition is disposed of on withdrawal. Next matter.
Item number 7.
No, serial number is that 2-3.
Item number 2.
My lord, in item number 2, I am arrayed as pro forma 4, and item number 4, I am arrayed as pro forma respondent 1. Now, these I had instructions only to appear in the transfer petition, my lord. So, if your lordship is taking up this item 2 and 3, my lord, let notice go, my lord. I don't have instructions to appear.
My lord,
In fact, my lord, I have
this is
to
just
file-
one way of protecting the proceedings. I object to it. This is what is the precise
So,
reason.
my lord, whether my
why we have
lawyer
asked-
can compel me to appear in this case when I don't
In
have
your
any
wakalat,
instruction.
it
my
was
lord.
not mentioned that you will appear only in this.
Yes, because transfer petition has come up for item
Transfer
number
petition-
1 with, so we have
petition
prepared in
contains
transfer
both.
petition.
This is just another method. Anyhow, if you have any personal difficulty, I won't object to it.
No, but I
that's not it.
personal difficulty without an instruction of the client, my lord. How do I appear? Tomorrow some proceedings is drawn up against me, my lord. I
Land
will
has
be
been-
receiving an.
Land has been captured. Airport land has been captured.
These are
and they are
matters of
just
merit, my
moving
lord.
on.
With all respect, my lord, these are
If
matters
you
of
have a
merit.
personal
Let a
difficulty,
notice be
I won't
issued.
object to it. I told you.
That is why, my
If you
lord.
have a personal
The
difficulty,
personal-
but
I
don't
don't
say
have authority
my
to-
wakalat does not.
I don't have the authority
That
to
is not
instruct you
correct.
to appear in item 2,
Not
my
correct.
lord.
It's incorrect.
In transfer petition, my lord, I had to file wakalatnama in transfer petition as respondent 1 in CRP 1 of 20, because in transfer petition, your lordship will kindly go through the cost title. There is no respondent or a number of opposite parties. So in transfer petition, when the clerk went to file the wakalatnama, my lord, the filing section was not willing to accept it because there is no respondent number in the transfer petition.
In which case you have filed your Wakalatnama?
I was instructed to file Wakalatnama in transfer petition. Now in transfer petition, when we went to file the Wakalatnama, your lordship will kindly see the cost title.
Then where you have filed your
In,
Wakalatnama?
CRP one, my lord, in CR that is 104.
Then how can you submit that you have not filed Wakalatnama?
No, in CRP two, I have not filed Wakalatnama. In the cause list, lordship will see my name is not reflected in CR item number 3.
No,
Which
if
was-
there was no Wakalatnama in the transfer petition, how can you appear and object?
My lord, transfer petition, because if your lordship, for a moment, if your lordship kindly take up the transfer petition, I will clarify it. My lord. For a moment, my lord, your lordship will kindly take up the transfer petition. Because in transfer petition at page, my lord, lordship will kindly come to page 1A of the transfer petition. Transfer petition, lordship got it, my lord? Now, lordship got, my lord? 1A, please.
Yes.
Now on top, your lordship will see, and in the matter of state of Nagaland is 1, 2, 3, 4, 5 versus Sri Vinoka Chisi and others linked with other civil revision petition and respondents. Now the filing section wanted to know that other linked cases means this, for whom I am appearing, who will be the respondent number, because there is no respondent number. Then your lordship will turn to page 2. In the matter of CRP 1 of 2024, so and so applicants, then 1, 2.
No, there's a respondents are there in the transfer petition.
Where is the, my lord, Vinoka Chisi and others linked with other civil revision petition. Now, in the transfer petition, this Tohuli, which number will be this, my client, which respondent will be in this transfer petition?
So names are there.
The names are what there.
Anyway, we have disposed of this petition.
That is why, my lord, in transfer petition, my lord, this 1 and 2, this 2, my lord, wherein the plaintiff is the respondent number 1, my lord, let notice be issued. This is for you are paying the cost for this for this one. Main case, main case, item 2. Next page it will be. It will see CRPC. It will share which will get into the main input. So it will just you're showing appearance of item 2
You see the cause list. Your name is there.
My name is in which, my lord, in which case? My name is there in which case? My lord will kindly clarify item number 2, that is 104.
You see the cause list.
I have seen,
where
my lord,
your
that
name
why I am
is?
submitting, my lord. 10, I have in the cause list. Because I was this when we went to the filing section to file the Wakalatnama in the transfer petition.
Okay, stop it.
Because in 2, I am the pro forma. In item number 3, I don't have filed any Wakalatnama.
Okay. Third, Mr. Balagopal, learned Advocate General for the state of Nagaland. This civil revision petition under section 115 of the Code of Civil Procedure, read with Article 227 of the Constitution of India, is directed against the order dated 29/9/2023, Hospital Learned Principal District Judge Dimapur, in civil appeal number 24 of 2023. It is to be noted here that by impugn order dated 29/9/2023, the Learned Principal District Judge Dimapur dismissed the civil appeal number 24 of 2023 and upheld the order dated 22/11/2021, passed by the Learned Civil Judge Senior Division Dimapur in IA civil number 224 of 2020, arising out of civil suit number 14 of 2020, and granted temporary injunction in favor of the respondent stroke plaintiff in respect of the land under DAG number 34 and 40 of developer area, restraining the state respondent. State revisionist struck defendant number 3 from executing the eviction order dated 11/12/2020 and obtaining the suit land pending disposal of the suit. It is to be noted here that this civil revision petition number 1/2024 was originally registered at Kohima bench of Guwahati High Court, and the same stands transferred to this court on the by the Honorable Chief Justice by order dated so and so advertised to go ordered. By order in the administrative site dated so and so so and so. Mr. A. Das, Learned Counsel for the respondent opposite party in IA number so and so so and so, submits that he has filed Ukalanama only in the IA and he has to take it back, appear in this revision petition from the concerned parties. And accordingly, Mr. Das submits that notice may be issued to the respondent hearing. Yes, Mr. Balagopal, you should notice.
My lord, I can just clarify in your lordship present order.
Hmm.
Lordship has said log number 34,
Hmm.
log number 38.
Hmm.
You must make that kindly, make that correction. 38 and 40. Inadvertently, your lordship mentioned log number 30. That's one.
Hmm.
As far as this case is concerned, the lordship would see.
No, that we will consider at the time of hearing.
Okay,
This is what you have mentioned in the cause title.
right. Now, is the cost schedule, if your lordship were to see,
Hmm.
the continuation of the cost of
Hmm.
at page 5,
Hmm.
is shown as performance difference number 14.
Hmm.
Now, in the continuing page, that is page number 6, is shown as Srimati Tohili. And this is in civil revision petition number 2 of 2024.
Hmm.
Now, when he is appearing for Tohili in whatever capacity,
Hmm.
he cannot say, I am appearing for him in that and not in this. Because the whole issue is civil revision petition number 2.
Hmm.
Ultimately, he is appearing in that. He has been defending that. If he had nothing to say, he would not have objected.
Hmm.
So that is in the next page. Srimati Tohili, page 6, it is given Srimati Tohili, wife of so-and-so, so-and-so. So when he is saying he is appearing for a particular place, when all avenues are blocked for an adjournment, now they say, I have been instructed only to appear in this and not in that.
Hmm.
That is unfair. They
But I strongly object to it.
Let me make my submissions, please.
Yes,
Let me make my
but
submissions.
don't cast aspirations of me, madam.
Sit down.
Therefore, I will not make any explanation. Therefore, once it is mentioned, Srimati Tohili is mentioned here,
Hmm.
that means they have accepted notice on behalf of Srimati Tohili.
Hmm.
Now, the whole transfer petition itself, what is being transferred? Transfer is being sought of Tohili's petition also, that is CRP number 2.
Hmm.
The confusion was whether CRP 1 and 2 are there. That confusion has now been sorted out.
Hmm.
While that confusion was there, they never said that I'm not appearing for this or I'm not appearing for that or issue notice.
Hmm.
That issue was never raised.
Hmm.
When this court is going to fix a date for hearing, that time they want to further prolong this matter. I'm not casting aspirations. I want to clarify that. So once you say you are appearing, and you are appearing for what? In whatever capacity you are appearing. It is the transfer petition. The whole thing is the transfer petition. The transfer petition contains both the CRPs. And in one he may be a performer respondent, and the other he is the respondent.
Hmm.
How can he, on what basis is he saying that my wakalatnama does not apply to that? On what basis? Once he is appearing in the transfer petition, it definitely apply to it. Because the transfer petition prayer is both CRP 1. Kindly see the prayer, my lord. Kindly see page 8. Or page 16, 16. 16.
Hmm.
In the premises is actually prayed, please to transfer CRP 1 and CRP 2. So both are mentioned.
Hmm.
So how can you say that I am appearing only in this? I'm not. That is not correct. That's why I say if there is a personal difficulty for the council is taking a little bit of time, I won't object. But not on this. This is not fair. Because the petition is, what is the petition about? Petition is about two parties. This person, Tohili, she is the wife of the original person, that is Atosha.
Hmm.
He expired. So his wife has come into the picture. So now the property, the linearity of the property is based on this particular Atosha. He has claimed that he is the owner and all that. I'm not going to the merits. Whether he owns or he doesn't own, that will come at the time of arguments. So in that transfer petition, when it came here, that is before this honorable court, and the transfer petition clearly says this is this and this is this. At that time, he never mentioned, I am only appearing for this, I am not appearing in that. He never mentioned that.
Anyway, since the matter has
I
been
leave it
transferred
here.
to this
I
court.
leave it to your lord. I leave it to your lord. I won't be unfair. But as far as the transfer is
Let
concerned,
the notice go, we will permit justice service to you.
as far as the transfer is concerned, that is confirmed. Lordship may confirm that. That's all.
In view of It does. This court is inclined to issue notice to the respondents returnable in 2 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Justice service is also permitted. List the matter on fixed date.
On 25th November. Letter number 3.
Would it be 26th, my lord? 26th. I was on now, what is this?
26th.
Can it be on 28 minutes?
No, not 28.
Then 29?
29 Friday.
My availability is not certain on 26th.
Yes, sir. I just will solve that out in just 1 minute. Let it be on 21st or 20th? No,
21st.
20th, 21st.
No, from that period, my lord, I'll be out of station. That's why I'm saying, because ultimately I'll have to come for adjournment. He'll try, then there
No,
will be.
madam, this need not be indefinitely postponed. This is on some technical portions that take, which I'm not making an issue of. Or let it be listed on this 17th. That's it.
1 week.
We'll issue thus the notice.
My lord,
We will see they are served. It can be listed on 17th. I'll come.
everything is so far he is concerned. It is an extraordinary case. And we don't have anything. My lord, we are saying only to fix on 29. Now he is going back to 17.
17th, that's what is required. They require
My
service.
lord, I can tell only on that date, my junior will ask her.
Anyway, we will oppose it, my lord, whatever it is, because this case is going on for too long. Your lordship has seen how in various methods, under one reason or other, it is
It is
being
the only
protected here.
exceptional case in the world.
Therefore, I am only requesting with great
So,
respect.
okay,
I
Mr.
will
Dutta.
have
just
them
want
served.
to talk,
It
but
is
he's
my
not
duty to serve them. They will
No,
be served.
okay. Mr. Dutta, Mr. Dutta, you are appearing for all the respondents in the item number
My lord,
3.
so for transfer petition, we have appeared. My learned friend already clarified, civil revision, we did not appear at all.
Mm,
Your lordship has seen the drafting or transfer in the post title.
mm,
We do not know for whom we should appear. That is the position. When
mm.
in the registry, your lordship will find the Wakalatnama could not be placed properly. Because
Mm.
they are also confused.
No, anyway, you are not appearing in this item. Item number
Civil
3.
revision, yet, your lordship kindly say, the transfer petition, when one file transfer petition, you are invoking section.
No. You clearly.
Let me clarify, my lord.
Huh.
Your lordship don't hear, your lordship will not understand.
Mm,
Now, transfer petition may be rejected, may be accepted.
mm,
Now, when it is accepted, then the civil division comes.
yes.
So that is the position only.
Mm,
Now, today, my learned friend, if you want to say that we are there, since we are there in the transfer petition, automatically we comes there also. Well, the fallacy of the argument.
no,
must
that's
be-
all right. You tell me, are you appearing for the respondents, all the respondents in item
we
number 3?
may appear if
That
my
is-
client asks us. That's
Okay,
the position.
okay. Same order. Okay. They were suggested that then
My lord, so far,
acceptable to both the parties.
29th, my availability is certain. Before that, my lord, I can't say with the degree of certainty.
29 November.
29th, I have explained my difficulty. I said 17th, 18th, 19th, up to 19th. Even though 19th, I will pass it. 19th.
So on 19th, it will not be 2 weeks.
20th.
28.
My lord,
Mr. Dutta,
as he is having personal difficulty, that's why, my lord, I have explained. On those periods, my certainty is not there, my lord. With a degree of certainty, I can say that 28 or 29, my lord, I'm here.
Well, in the first place, he is not clear whether he is going to appear, whether he has instructions.
Oh, that's up to
So-
my client.
Yeah,
Who
so
are you to
therefore,
say?
He is not saying,
He want
he should
that I
not
should
have a
assure your
grievance.
lordship whether I
He
am
don't have a
appearing.
grievance because.
Your
he-
lordship has issued
Yeah.
notice.
No, I will.
He's asking me that whether I should appear or not. Is he my client? Let it be on second melody. Both my landlord seniors have problem.
No.
On
No,
second,
madam.
it's a Monday.
It can be kept on 20th.
No, we have directed to list the matter after 2 weeks. So
Okay.
immediately after 2 weeks, if it is a 20th, okay, on 20th November.
20th, keep it on 20th.
What I'm praying.
They are not clear whether they will
All right.
appear or not, keep it on 20th.
Because there is also uncertainty that you may not appear also. Yes.
20th.
Okay.
On 20th November.
Lordship in item 3 also, Lordship has issued notice because I don't appear in item 3 also.
Already ordered.
Yes, because in I had appeared for in pro forma 14 in the item number 2. The pro forma who is item number 14 is pro forma in pro forma 14 in item number 2, and she is respondent number 1 in CRP 1, item number 3.
Okay.
So in my lord, item number
It
3,
does.
notice has to be issued. No one has appeared, my lord. Completely obliged.
Sergeant number 7 for orders.
That in this case, we have taken steps now.
This I is for what purpose?
So, for extension of interim order and everything. আগে তো আসতে হবে লাখ টাকা কথা The last occasion this appeal was admitted. We
Yes.
have taken steps. Appeal was admitted on 25th 9/2024.
When the next date is fixed?
Yeah.
After 4 weeks. After 4 weeks.
Mhm. Appellant shall take stays for the issuance of the notice
Okay.
after 4 weeks.
Heard Mr. A. Dasgupta, learned senior counsel assisted by Miss learned counsel for the applicant. Mr. Dasgupta submits that
Steps have been taken that.
in the regular second appeal, notice has already been issued. Notice has already been issued by this court by order dated 25/9/2024, admitting the second appeal to the respondents. And in the said RSA, this interlocutory application was filed for staying operation of the for staying execution of the judgment and decree dated 38/5/2023 passed by the learned civil judge Gulagat entitled appeal number 5 of 2017. And as they have taken a step, as the applicant has taken a step in the regular second appeal upon the respondents, and as the said RSA has not yet been listed, the interim order dated 25/9/2024 is staying the operation of the execution of the judgment and decree dated 38/5/2023 may be extended. Fair is accordingly allowed. List the matter after 2 weeks.
Much obliged.
Whenever this regular second appeal is taken up, you may submit for making this interim order
Absolutely.
absolute till disposal of the RSA.
Now the interim order may extend till that date. Much.
For hearing. Item number 9.
1982. You are for the appellant.
Lordship.
The other side appeared and prayed for adjournment.
Lordship,
They inform you.
oh, Lordship, we adjourn Lordship morning time.
Junior
Yes,
or
sir, sir.
SCPS? Addition. Opposite party appeal one, legal was appeal
9, no?
9. Item 9. Okay. Ultimately, morning on the adjournment. Petition.
Your good name, please?
And Kakoti Lordship.
Miss N. Kakote, learned counsel appearing on behalf of. No, heard Miss N. Kakote, learned counsel appearing on behalf of Mr. S. C. Kyle, learned counsel for the appellant. None appears for the respondent on call. Ms. Kakote submits that the matter may be adjourned for the day or
2 weeks Lordship.
maybe adjourned. A press for listing the matter after 2 weeks period is accordingly allowed. Rest is the matter after 2 weeks. Okay.
Highly obliged.
We'll fix it that, madam.
On 3rd December. On 3rd December. Item number 10.
The suit was for specific performance of contract, Your Lordship. I was the defendant and learned firm was for the plaintiff. The suit was dismissed. Just before starting, Your Lordship, there was order dated 22/2/2016, whereby this was admitted, this appeal was admitted. Perhaps due to oversight, substantial questions of laws were not framed at that point of time. Order dated 22/2/2016. Only the grounds are reflected in the order. I suggest the substantial questions of law that is in page number 3 of the memo of appeal. Your Lordship. The fact is that it was an unpartitioned property, Your Lordship, and there was an agreement for sale for one portion of the property initially.
So you have filed the title suit number 22 of 2006 before the Court of Munsif at Bongaigaon.
At Bongaigaon.
Bongaigaon. And learned trial court has decreed the suit.
Learned trial court has decreed the suit
Decreed the suit in favor of the plaintiff.
in favor of the plaintiff.
And against that decree, you have preferred an appeal
Yes, Your Lordship.
before the learned civil judge senior division.
Civil Justice Senior Division. Lordship.
Bongaigaon.
Bongaigaon.
And the civil judge senior division Bongaigaon has dismissed the
Dismissed that.
and thereby affirmed the
Affirmed the judgment and decree of the learned.
passed by the Munsif. So there is concurrent finding
Yes,
of fact by the courts below.
Until and unless there is a question of law here, Your Lordship, cannot be decided.
Now you tell me what is the question of law? Substantial question of law.
Lordship, there are two things, Your Lordship. I'll just go to the facts very briefly, Your Lordship. There was a total plot of land measuring 3 katha and 15 lesas, Your Lordship. It is reflected in Schedule A. Out of that, the plaintiff's contention is that, first of all, we entered into an agreement for sale for 1 kata and 5 lessa out of the total plot of land
Hmm.
for a total consideration of 42,000 rupees.
Hmm.
Thereafter, after execution of the agreement for sale, your lordship, the parties again agreed that the remaining portion will also be purchased by them. So subsequently, another agreement was there for remaining 2 kata 10 lessa.
Hmm.
And it was decided between the parties that both, it is their contention that both the sale deeds will be executed on the same date. However, on the date of that execution, only the sale deed for 2 kata 10 lessa was executed
Hmm.
and not the agreement for the previous 1 kata and 5 lessas. Thereafter, it is their contention that they were pursuing for sale of this amount, this portion of land as well, but somehow we were denying or we were not ready and willing to sell them. So as such, they filed the specific performance of contract for that another portion of land. Our contention was that, your lordship, initially there was an agreement for that previous 1 kata 5 lessas. Subsequently, when they tried to purchase another plot of land 2 kata and 10 lessas, your lordship, then that previous advance that we have received was adjusted with the subsequent land, and they have purchased that. And the previous agreement that was standing as on that date extinguished, your lordship. That was not there after that, after the purchase of 2 kata 10 lessa.
Hmm.
That was the contention of the defendant number 1. Defendant number 2 says, your lordship, it was an unpartitioned property. Defendant number 1 on his own could not accept all the amount and sell the entire plot of land. The question of selling the entire plot of land and receiving the amount by defendant number 1 alone is not legal, your lordship. As such, defendant number 2 filed a separate WS and contested the suit. He also filed a counterclaim which was dismissed. He did not challenge that. So under such circumstances, your lordship, the substantial question of law that is suggested, your lordship, question number 2 at page 3.
Hmm.
Whether Exhibit 7, a receipt issued by defendant number 1, would have been binding upon defendant number 2 when such receipt was not issued as per his knowledge or consent, nor the said receipt had any link or relevancy in connection with the alleged agreement entered between plaintiff and defendant number 1 and disputed by defendant number 2.
No, that is a question of fact.
Because
So substantial question of law would be only on the point of law there, and there must be substance.
yes, your lordship, in that case, if I have to rephrase this, question number 3 as well, your lordship,
Hmm.
whether in absence of any evidence, oral or documentary, that defendant number 2 had agreed to sell the unpartitioned joint property, received any payment, any decree of specific performance of contract could have been passed, and whether such a decree could be enforceable on the defendant number 2. Because the ground that the defendant number 2 took is that it was an unpartitioned property. Defendant number 1, whether or not he has received or not a portion, an amount, whether that receipt would have been agreeable by the defendant number
So
2.
this appeal is preferred by the defendant number 2.
1 and 2 both. Your lordship.
Hmm. Then it is the defendant number 1 who has received the amount
Yes, your lordship.
after selling the property to him.
The property, entire property was 3 kata 10 lessas here. 3 kata 15 lessas, your lordship.
Hmm.
Out of that, one portion is already sold. There is no dispute regarding that.
Hmm.
There is 1 kata 15 lessa out of 1 kata 5 lessa out of the 315,
Hmm.
which was previously agreed between the parties for sale.
Hmm.
Subsequently, there was another agreement,
Hmm.
2 kata 10 lessa.
Hmm.
Subsequent portion they have purchased. The contention of defendant number 1 is that when there was subsequent agreement, the previous amount that he has received against 1 kata 5 lessa was already adjusted with the second agreement, second sale deed, your lordship.
Hmm.
As such, the previous agreement for sale against which they have now paid for specific performance was extinguished.
Hmm.
So they have purchased the second portion and the first portion was untouched, your lordship.
Hmm.
It was the contention of the defendant number 1. And defendant number 2 says, even if he had accepted an amount, defendant number 1, and even if it was not adjusted as well, whether that amount would have been a binding on the other party, the other brother, who was also a joint owner of the property.
Hmm.
So there were two separate WS for both the parties, your lordship. So the substantial question of law suggested in page 3, number 1 as well, your lordship. Whether the decree for specific performance of contract would have been passed in respect of a joint and unpartitioned plot of land on the strength of agreement entered by one of the joint owners and denied and objected to the other joint owner. Whether a specific performance of contract can be granted on that ground. It is a suggested substantial question of law.
Yes,
My lord. He has fairly submitted, only thing that defendant number 2, who has signed the exhibit 1, the agreement to sell 1 kata 5 acres to the plaintiff in title suit. And the agreement is in the exhibit 1, I think in the case in the main record, in my the page 20. The agreement in there, my lord, exhibit 1. Your lordship will see that both the defendants have signed that as exhibit 1 and 2. Exhibit
Page
1,
number
1 and 1, 2.
at page number.
Page number 25. LCR. So your lordship, Dolil and all agreement.
LCR.
Yes. Records.
Page number
25.
25.
Title suit. Exhibit 1. Your lordship said, you see that both the defendants have signed that agreement to sell 1 kata 5 acres to the plaintiff. So what I'm submitting that, you have to come with clean hands. Here, when without partition, this exhibit 1 was executed by defendant number 1 for sale of 1 kata 5 acres to the plaintiff. They again sold remaining 2 kata 10 acres to the wife of the plaintiff. In this selling of 2 kata 10 acres to the wife, this defendant number 2 has no objection. He has no counter claim, nothing. But when it has come to the case of just rejecting the statement, that is therefore they are submitting that alleged story. But thing is that it's not alleged story, it is all the exhibits from 1 to 11 documents are there, exhibited by the plaintiff will show that the defendant number 1, who is a doctor, he has now filed a counterclaim to show that unpartitioned, that is the legal, the 3 issues, substantial point, the 3rd point he is saying that is not that amount received by defendant number 1 on behalf of defendant number 2 is not applicable to him. So hence the counterclaim. My submission is that when same land, same part of the land, he has no dispute to selling to the wife, taking more amount. Here also exhibit 1, they executed very nicely by these two, this exhibit 1, but later only even they prayed for extension, the enhancement of the amount from 40,000 to 82,000. That also was, but that is exhibit 7. That is exhibit 7, the dispute, the defendant number 2 does not admit that I did not, because defendant number 1 accepted the money. When he accepted, he executed, is not applicable to me. But here, when it came to the execution of the sale to the wife, he has no objection. But when it is comes to the sale of execution or sale of to the plaintiff, he has the objection. So my submission is that he has not come with the clean say, and here the both the in title suit and the first appellate court have decided 4, 5, 6 the issue number regarding to the agreement exhibit 1 and 7, 8, 9, 10 regarding the counter claim.
while dismissing the counterclaim, the limitation point, and all everything discussed very clearly, and there's nothing to, it's such a clear case by the trial court and the first appellate court that all the issues have been clearly discussed. And the legal points, as Lordship has submitted, that there is no legal points here, only that they are denying only because the unpartitioned property was sold, signed, not sold, signed and received money by the defendant number one, his younger brother. This thing has happened in both the plots. Somewhere he has signed, somewhere he has not signed, but they have not said that the only when the specific performance of contract this case, because for possession also they were given, the plaintiff was given possession on the very first day after the agreement was signed in 2001. So possession was there, everything was there, only the enhanced money was also given. But then when there's a case for 145, 146.
So this exhibit 1 is the first agreement.
Yes.
And the second agreement is at page number?
This is why that this is a LCR page 27. Exhibit 4, page 28.
28.
Exhibit 4, agreement for sale dated 17/8/2000, executed by the defendant in favor of Srimati Joya Medinath. And even the DW2, that he has in his cross clearly admitted all these things.
So, Mr. Mukherjee, this exhibit 1 contains the signature of both the sellers.
Both the sellers. Lordship,
And exhibit this 5 also.
5 also both the sellers. I'll just give the timeline. Lordship may note your lordship.
Mm.
Exhibit 1, it was executed on 25/4/2001.
1.
It was by both the parties for selling of a plot of land measuring 1 kata 5 lesses. Thereafter, what happened, your lordship? NOC was applied for, it was obtained, and everything was there. Thereafter, there was another agreement for sale, which is at Exhibit 4, 17/8/2001. Here also both the parties signed, your lordship, for sale of 2 kathas 10 lesses, double the amount of land in the first agreement, to the wife of the plaintiff. Subsequent to this, your lordship, Exhibit 4, Exhibit 5 was executed. It is a registered sale deed. 2 kathas 10 lesses in favor of wife of the plaintiff, your lordship. Thereafter, your lordship, what happened? The first agreement for sale that was executed on 25/4/2001, there was no registered sale deed as of date, your lordship. Only the second part was executed. The contention of the defendant is that since they have purchased the second portion, the previous amount that was paid, your lordship, that was adjusted with this one, and this agreement, this sale deed was registered. The plaintiff's contention is that, your lordship, thereafter we have asked for higher consideration, and subsequently Exhibit 7 was there was an agreement between them, and Exhibit 7 was executed, whereby the fresh consideration was increased to 82,000 rupees, and another 30,000 was taken as advance by the defendant number 1. This is the facts as stated by the plaintiff. So if this is the condition, your lordship, there is a fresh agreement that has been entered between the plaintiff and the defendant number 1 for the sale of the previous plot of land. Earlier, we had received some amount, and both the defendants are of the same view that they have sold a portion of land. For the first agreement, your lordship, as on date after the execution of the sale deed of the 2 katha 10 lesser, the contention of the defendant is that the previous agreement elapsed. But the plaintiff says it was very much there, and to that extent that they have agreed to enhance the amount, and fresh amount of 30,000 was paid by way of Exhibit 7,
Hmm.
which was accepted by defendant number 1 only, and not defendant number 2. So whether this acceptance of enhanced amount, this will amount to another agreement by whereby we are showing that there is readiness and willingness between both the parties to purchase.
No, tell me specific performance was granted for this performance of which contract, which agreement?
The previous one katha 5 lesson.
Hmm.
Second one, there is no dispute.
Hmm.
The contention of the defendant is that when the second one was executed, the registered sale deed was also executed
Hmm.
for 2 katha 10 lesson.
So this exhibit 1.
Exhibit 4 was the agreement for sale. Exhibit 5 is the sale date.
No,
Previously, there was
there is a
exhibit 1.
dispute in respect of exhibit 1.
Exhibit 1 only. After exhibit
So
1,
this exhibit 1 contains a signature
signature
of
of
both the
parties,
brothers.
both the parties. Your Lordship.
Yes.
Thereafter, exhibit 4 also has signature of both the brothers.
Hmm.
Exhibit 5 is the sale deed in respect of the plot of land measured in stated in exhibit 4.
Hmm.
Both the brothers says when this sale deed was executed for this exhibit 4 land, the previous amount that has been received in respect of exhibit 1
Hmm.
was already adjusted, and exhibit 1 ceased to have any effect.
Oh, whether there was any reference in the exhibit 4
No,
about
no.
this exhibit 1?
No, Lordship. To that effect, to that effect, directly there was no reference. I could not find any reference.
Then how
about
can
it.
you argue on that point?
But in the schedule of the sale deed, Your Lordship,
Hmm.
it was stated in this
No, yeah.
in Dokhin, Your Lordship, in the schedule of the sale deed of exhibit 5, Your Lordship.
Hmm.
Initially, there was something, then there was written Bikreta Nizamati, Your Lordship.
Hmm.
The seller's own land is there in the west.
Hmm.
And initially there was a writing, Your Lordship,
Hmm.
Ami An Dolil Putte
Hmm.
Profullo Nathar Khorida. That was struck off. That means, Your Lordship will see, peruse the schedule of the sale deed, Your Lordship. In the southern side, Dokhin. Initially, there was an intention to sell that to Profullo Nath, but that was struck off, and it was stated that Bikreta Nizamati.
Hmm.
So this goes to show that when the second this sale deed was registered,
No,
Your Lordship,
maybe in the boundary there may be some similarities, but what you have stated is not mentioned in the exhibit 4.
it is not directly mentioned. I could
Then?
not find any such thing,
Hmm.
but it is stated in the schedule.
Hmm.
Earlier, it was stated that An Doliledi Dolil Putre Profullo Nathe Koridamati towards south. That was struck off, and it was mentioned that Vikreta Nizamati. Here the intention of the party is clear, Your Lordship. The earlier intention to sell that plot of land to Profullanath by another deed was struck off, and it was stated that it was the own plot of land of the sellers, Your Lordship. As such, the previous agreement for sale extinguished, Your Lordship. And thereafter, even after that, Your Lordship, the timeline, as I was suggesting, this agreement for sale, this sale deed was registered in the year 2002, Your Lordship. 15/3/2002. 2003, 2004, there is nothing. In November 2004, they have alleged this Exhibit 7 came into being. Both the agreement for sales of 1 katha, 5 lesa and 2 katha, 10 lesa were of the year 2001. Thereafter, in 2002, this sale deed was registered. 15/3/2002 for one portion of the land to the wife of the plaintiff. 2003, 2004, there was no communication between the parties that we need to purchase the other plot of land as well. There is nothing. They come with the fact that in November 2004, the defendant number 1 had accepted another 30,000 rupees by way of Exhibit 7. As such, the previous agreement is very much alive. And this gives a fresh cause of action, gives rise to a fresh cause of action. Since after 2 years, it is their statement that I have paid for enhanced amount of money and they have agreed to that. And this defendant number 1, to that extent, has received another 30,000 rupees by way of Exhibit 7, which says that they were ready and willing, they have paid the enhanced amount after 2 years and it has to be executed. The agreement dated 2001, Your Lordship.
Where is the plaint?
Plaint.
Have you enclosed it in the appeal?
Yes, yes, Your Lordship. It starts from page number 57.
Fifty-seven is the amended plaint.
Yes. Page 50 is the type of law.
50.
50 is the decree, I think. Decree. 57 is the amendment. One interesting thing at page para 10 of the plaint is there. At page 60. Just to show the discrepancy. Para 10, if I may read.
So the pair was only for specific performance of the contract dated 25/4/2001.
The suit was filed in the year 2005, Your Lordship. Alleging that there has been another money that was paid in 2004. Which was only signed by one of the defendants.
No, while the pair relates to only agreement dated 25/4/2001, and pair is also relates to the same.
Yes, Your Lordship.
So how the impugn judgment and decree so passed by the trial court and affirmed by the first appellate court suffers from any infirmity or illegality?
Lordship,
Hmm?
the thing is readiness and willingness, your lordship, one of the things. The agreement that for which the specific performance of contract was paid for is of the year 2001, your lordship.
Hmm.
The suit was filed in 2000.
No, is there any time limit in the agreement?
No, your lordship.
Then,
It has to be within 3 years from the date of refusal.
hmm,
Our stand is that, your lordship, when the registered sale deed in the year 2002, 2002 was executed between both the parties,
hmm,
the previous one ceased to exist, the previous agreement for sale. Thereafter, the contention of the plaintiff is that in 2004,
hmm,
we have paid for an enhanced amount in after agreement, just para 10, your lordship,
hmm.
page 60. That the defendants came to the office of Sub-Registrar Bongaigaon along with the plaintiff and his wife, Jaya Medhinath, on 15/3/2002 and engaged one deed writer to prepare the sale deed for both the plots of land describing Schedule B and Schedule C. Below on the stamp papers furnished by the plaintiff and his wife, Jaya Medhinath. Accordingly, both the sale deeds in respect of
You are reading
para 10, your lordship,
of the
860, plaint. 860.
yes.
That the defendants came to the office of Sub-Registrar Bongaigaon along with the plaintiff and his wife, Srimati Jaya Medhinath, on 15/3/2002 and engaged one deed writer to prepare the sale deeds for both the plots of land as described in Schedule B and Schedule C. Below on the stamp papers furnished by the plaintiff and his wife, Srimati Jaya Medhinath. Accordingly, both the sale deeds in respect of the suit land and the plot of land described in Schedule C below were prepared by the deed writer. When the sale deeds were prepared and were ready for presenting before the sub-registrar Bongaigaon on payment of the balance amount of consideration of 1,35,000 for execution to the defendants by Srimati Jaya Medhinath, wife of the plaintiff, in respect of the plot of land described in Schedule C below, the defendants all on a sudden made a proposal to the plaintiff that they would execute the sale deed in favor of Jaya Medhinath, wife of the plaintiff, in respect of the plot of land described in Schedule C below on that day, and told that the plaintiff would execute the sale deed in respect of the suit land within a period of 2 months from the due to some difficulties which they did not explain clearly to the plaintiff. The plaintiff was further assured that the stamp papers used for preparing the sale deed along with the draft made therein would be utilized while they would execute the sale deed. So the plaintiff is not required to incur loss. The plaintiff believed the defendant in good faith, and for that he did not insist that the defendants to execute the sale deed in respect of the suit land on that date. Accordingly, the sale deed in respect of the plot of land described in Schedule C below was executed. We have no dispute regarding that. By the defendant in favor of wife of the plaintiff, Srimati Jaya Medhinath, on 15/3/2002, on receipt of the aforesaid balance consideration of 1,35,000 only. It is pertinent to mention here that rupees 70,000 only has been mentioned in the registered sale deed number so and so, executed in favor of Srimati Jaya Medhinath by the defendants in pursuant to the valuation fixed by the additional deputy commissioner in the land sale permission in respect of the plot of land mentioned in Schedule B, even though the amount of consideration was fixed at 1,40,000 and payment thereof was made in full to the defendants by the purchaser, Srimati Jaya Medhinath. They have contended that the consideration for the entire plot of land was 1,40,000, but the registered sale deed contained only 70,000 as mentioned in the registered sale deed, your lordship. So this being the position, your lordship, the contention of the defendant.
No. If both the parties, both the brothers signed in the agreement
Lordship.
dated 25/4/2001,
Lordship.
how we can frame this as substantial question of law?
In that case, I would suggest another substantial question of law, which will go to say that the exhibit dated exhibit of 2004, 25/11/2004,
Hmm.
which was a subsequent agreement, whether that could be inferred as a continuation of events or showing readiness and willingness on the part of the defendant, on the part of the parties for sale of the previous plot of land. Because if both the parties were silent after this registered sale deed for a long period of time, and in 2004 they have just shown that there is another advance for
No,
which
there is no time limit in the
agreement.
agreement. Time
But-
is not the essence.
Time is not the essence, but when the suit has to be filed within a period of 3 years
Hmm.
from the date when they have observed that we have refused to execute the agreement,
Hmm.
Your Lordship. For that, Your Lordship, they have shown Exhibit 7, Your Lordship, saying that in 2004 we have entered
No,
into
they were present, no, the plaintiff was present in the sub-register office with the money.
in 2002, Your Lordship.
Uh,
They have filed the suit in 2006, Your Lordship.
hmm.
Just to show that 2006 is within 3 years from the date of our refusal, they have said that 2004 they have paid another advance of 30,000,
Hmm.
which one of the brothers has executed.
Hmm.
So whether this 30,000 payment is in respect of this plot of land, that is also not clear. Exhibit 7, if Your Lordship peruses the record, Your Lordship, Exhibit 7 is also not clear as to why this 30,000 was paid. Whether it was in respect of that plot of land mentioned in 2001 agreement
Hmm.
is not clear from Exhibit 7.
Exhibit 7 is at page number
Exhibit 7 is at LCR, Your Lordship.
LCR.
It is also
It relates to 1 Katha 5 lesa of land. It has been mentioned there. Mr. Mukherjee,
Lordship.
you see this exhibit 7 original copy from the.
Records.
Huh? We'll resume after 5 minutes.
Lordship.
So in the exhibit 7, it has
It's clearly mentioned that
in respect of 1 Katha 5
Five
lesa
lesa.
land.
the only thing that is left here, Your Lordship, is the Exhibit 7 is signed by only one of them, whereas the agreement for sale was signed by both the brothers, Your Lordship.
Hmm.
Under such circumstances, I may not have much to say regarding that, Your Lordship, because the previous agreement has consent of both the brothers.
Hmm.
And only the advance amount, to the extent of advance amount, one of the brother accepted the advance amount for the sale of the entire land, Your Lordship.
So there appears to be no substantial question of law in this appeal.
Yes.
Hmm?
Under such circumstances, Your Lordship, I would just have molded prayer, Your Lordship.
Hmm.
Lordship has seen the agreement is of 2001. The balance consideration, total consideration was 80,000.
Hmm.
The balance consideration is 10,000 only.
Hmm.
So if Your Lordship pleases, Your Lordship, I would place reliance on one judgment.
Hmm.
If specific performance of contract is directed, Your Lordship, by this court,
Hmm.
at least the present government value, not even the market value, government value of the land may be considered, so that there is no loss to the government revenue as well, and both the parties can be sufficient.
No, that cannot
I would
be a
just place-
substantial question of law.
That is not a substantial question of law.
Hmm.
While dismissing the case as there is no substantial, devoid of any substantial question of law,
Hmm.
I would just place one judgment, Your Lordship, for the
Hmm.
times.
Mr. Mukherjee,
Lordship.
any such direction must relates to the substantial question of law. If there is no substantial question of law,
It will be
can
dismissed.
this court issue such direction? Hmm?
In Para 30, Your Lordship, page 718,
Para?
30. Page 718, Your Lordship. Subpara 18, 19, your lordship, 18 and 19. Subsequent price rise will not be treated as a hardship entailing refusal to decree for specific performance. Rise in price is normal change of circumstances, and therefore not a ground a decree for specific performance cannot be reversed. However, the court may take notice of the fact that there has been an increase in the price of the property, and considering other facts and circumstances of the case, court, while granting decree for specific performance, can impose such condition which may to some extent compensate the defendant owner of the property.
No, you have not executed the sale date. You are responsible for the delay. You cannot take the benefit.
That is understandable.
You cannot take the benefit. So we are dismissing this appeal.
There appears to be no substantial question of law.
Heard Mr. Bija Mukherjee, learned counsel for the appellant, and Mr. S.K. Soria, learned counsel for the respondent. The second appeal is directed against the judgment and decree dated 7/9/2015, passed by the learned civil judge Bongaigaon in title appeal number 8 of 2012.
18.
Title appeal number
18 of 2000.
You come to your
Post title.
memo of appeal.
Post title, I think there's a typing.
18.
Will be 18.
Title appeal number 18 of 2012. 2012. It is to be noted here that by the impugned judgment and decree dated so and so, the learned civil judge Bongaigaon has dismissed the appeal and affirmed the judgment and decree dated 18/5/2012, passed by the learned civil judge, by the Munsif, in TS number 22 of 2006. Mr. Mukherjee, learned counsel for the petitioner, submits that while admitting this appeal for hearing by order dated 22/2/2016, no substantial question of law was framed, and in the order dated 22/2/2016, only the grounds have been mentioned. And as such, there is a requirement of framing of substantial question of law here in this appeal. Mr. Mukherjee, referring to page number 3 of the memo of appeal, submits that there he has suggested 3 substantial question of law, and the same are accordingly: number 1, whether the decree for specific performance of contract could have been passed in respect of a joint and unpartitioned plot of land on the strength of agreement entered into by one of the joint owners and denied and objected by the other joint owner. Question mark number 2, whether Exhibit 7, a receipt issued by defendant number 1, could have been binding on defendant number 2, who, when such a receipt was not issued as per his knowledge or consent, nor the said receipt had any link or relevancy or connection with the alleged agreement entered between the plaintiff and the defendant number 1 and disputed by the defendant number 2. Number 3, whether in absence of any evidence, oral or documentary, that defendant number 2 had agreed to sell the unpartitioned joint property or received any payment, any decree for specific performance of contract could have been passed, and whether such a decree could have been enforceable on defendant number 2. Accordingly, Mr. Mukherjee submits that out of the 3 suggested substantial question of law, the substantial question of law 1 and all the substantial question of law are material, and accordingly it is contended to frame the contended to formulate the aforesaid substantial question of law to decide this appeal. Whereas Mr. Mukherjee, Mr. Soria, learned counsel for the respondent, vehemently opposed the submission so advanced by Mr. Mukherjee. Mr. Sohoria, learned counsel for the respondent, referring to Exhibit 1, submits that in the said agreement, both the brothers have put their signatures and received a sum of rupees and fix the sale consideration at rupees 42,000. And by Exhibit 7, one of the brother has received the amount of rupees 30,000 from the respondent. 30,000 from the respondent. And the decree was granted by the learned trial court in respect of a plot of land measuring 1 kotha 5 lesa described in Schedule B of the plaint. And the decree was also granted in respect of the aforesaid schedule. And that the learned trial court and also by the First Appellate Court, considering all the aspects, considered all those aspects in their respective judgments, and as such, no substantial question of law is involved in this appeal, and therefore it is contended to dismiss the same. Copy. Having heard the submission of learned advocates of both the parties, I have carefully gone to the petition, carefully gone to the memo of appeal and the grounds mentioned therein, and also the suggested substantial question of law. And it appears that there is concurrent finding of fact by the learned trial court and also by the learned first appellate court. First appellate court. It is well settled by the Honorable Supreme Court in Catena of decision that concurrent finding of facts by the trial court as well as first appellate court is binding upon the High Court. Reference in this context can be made to a decision of Honorable Supreme Court in the case of Sandrika Singh, written dead by ALRS and another versus Sarjuk Singh and another, reported in 2006, 12 SCC 49, page number 49, wherein it has been held that within inverted comma, serial number 12. While exercising its jurisdiction under section 100 of the Code of Civil Procedure, the High Court is required to formulate a substantial question of law in relation to a finding of fact. Full stop. The High Court exercises a limited jurisdiction in that behalf. Full stop. Ordinarily, unless there exists a sufficient and cogent reason, the findings of fact arrived at by the courts below are binding upon the High Court. In the case of Sako and another versus Mahadevan, reported in 2007, 7 SCC, page number 363, while dealing with the jurisdiction of section 96 and 100 CPC, Supreme Court has held that serial number 6, inverted comma, it may be mentioned that in a first appeal filed under section 96, the appellate court can go into questions of fact, comma, whereas in second appeal filed under section 100 CPC, the High Court cannot interfere with the finding of fact of the first appellate court, and it is confined only to question of law. Question of law. In the case in hand, it appears that both the courts below have rightly appreciated the facts in its proper perspective and arrived at a reasoned decision. And the same are based upon the pleadings of the parties and also the documents exhibited before the learned trial court. Thus, having examined the impugned judgment and orders so passed by the learned trial court and also by the first appellate court, and also considering the suggested substantial question of law, in the light of facts and circumstances on the record, this court is of the view that no substantial question of law is involved in this appeal, and the concurrent finding of both the courts below are in respect of the facts are binding upon this court, and therefore this court is inclined to dismiss this appeal. Send down the record of the learned courts below, along with a copy of judgment and order of this court. The parties have to bear their own cost.
Number 12.
You have to mention courts, no?
Maybe.
Yes.
We have taken it from the other.
Acha. Any objection?
Lordship, actually, we were supposed to do the matter, but if the engaged council wants some more time, then one date may be granted, Lordship.
Okay. Mr.
Yes, no. On behalf of LR Mazumdar.
A Islam Learned Council appearing on behalf of Mr. L.R. Mazumdar. Learned Council for the appellant with concern from the other side, press for listing the matter after. After?
Tuesday.
Hmm.
Tuesday, Lordship, next Tuesday.
Next Tuesday, not
The
possible.
month of December,
In first week of December, Lordship.
okay, 5th December. On
Bless.
5th December. Item number 13.
Who is for the other side?
Lordship, item 13.
Yes.
Lordship, my senior is on his way to this court, Lordship. Password a matter for a time being, Lordship.
Time being.
That will be at 2 PM, my lord, otherwise.
2 PM.
Item 14 to 17.
My lordship, for time being, Mr. B. Pupester is on leg. You can take after some time.
Then at 2 o'clock.
Bless.
Lordship, with regard to item number 14 to 17, Your Lordship, Mr. B. Gogo is supposed to appear for the matter. Your Lordship is on legs in court to amidst a matter regarding a medical admission. Today being the last day, Your Lordship. So the matter may be taken up any day next week, Your Lordship.
On 12, it may be fixed.
Pardon?
On 12, it may be fixed.
12.
12.
Yes, your good name, please.
RM Bora, Your Lordship.
Miss R.M. Barua.
Lordship.
Learned Counsel appearing on behalf of Mr. Gogoi, B. Gogoi, Learned Standing Counsel for
Finance Department, Your Lordship.
Finance Department. Submits that he is in leg in court number 2 in connection with an urgent matter, and as such, with concern from the other side, Ms. Barua press for listing the matter when?
On 12.
12.
Mhm.
12. Okay, fair lot. Rest is list the matter on 12.
Item 13.
My lord, in this case, I am for the appellant.
Hmm.
Well, I could not prepare the case thoroughly, my lord. Therefore, some accommodation for my lord. Day after tomorrow, or any other.
Mahmood,
Lordship.
day after tomorrow possible?
But we have some urgency, so.
No, there is no, they have no, on the last day, they were absent.
I understand the scenario.
December. No, this month. 12 or 19. Can it be on 12?
12.
No. This month.
11.
Yes,
I have no objection, but.
12. Mr. S.C. Sharma, Learned Senior Counsel, assisted by Mr.
Engomola.
Learned Counsel for the appellant with consent from the other side, press for listing the matter on 12. Fair lot.
Okay.